Looks like we are live.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
We want to welcome you to the January 6, 2021 settings of the 7th Court of Appeals via Zoom and YouTube. We appreciate the attorneys and the judges appearing through electronic means, the way of the future and or of the present now too, and appreciate your cooperation in this. We will go on and call the docket, and given that you are here, we know that you are present and ready, but it's just more of a formality to indicate that we are proceeding forward. Both of you are familiar with the court, and you know how we operate. You know that we ask questions, sometimes play devil's advocate, so we will not go through all that discussion. And you also know the time parameters that are assigned to the parties that are arguing, so we will not discuss that. But with that, we'll start with 07-19-00395-CD 2027 South Austin Street, LLC, and Paul B. Christy versus LaTour Condominiums, Inc. I would say the appellants.
We are ready, Your Honor.
Thank you. And that, please.
Ready, Your Honor.
Very good. And again, we wish both of you a happy new year. And you are the first argument we have for this new year. So you're starting us off in good form, and we appreciate that too. So Ms. Knapp, you have the floor.
May it please the court and counsel. The Texas Supreme Court has described the doctrine of adverse possession as a harsh one because you're taking land from a landowner without consent or compensation. And the court describes that before taking this severe step, the evidence should be very clear. And this is especially true in the context of a summary judgment, and I'll address that issue first. The trial court here granted LaTour's traditional summary judgment, even though LaTour and in its evidence had admitted that north of the diagonal deeded boundary line in this parking lot was 2027's property, that the poles placed just north of that line were not on LaTour's property. They were on 2027's property, that LaTour was not actually claiming ownership of that property north of the wedge, and that the use of the parking lot and the driveways to the parking lot had been had been used mutually by both sides.
Counsel, let me interrupt if I may and ask you this. There are two aspects, I guess, to this case. There's a summary judgment and a trial. Is the outcome of the trial issue dependent upon the outcome of summary judgment? Well, to the extent that if we were to say that the trial court erred in granting summary judgment, would that pretty much require a new trial?
Well, not necessarily, because I guess there could be errors in both. But I think maybe what you're getting at is perhaps the easiest way to dispose of the appeal would be to reverse and remand on the summary judgment and just remand the entire case. I think,
and I guess that's my question. If we were to reverse and remand, and of course, devil's advocate, but if we were to reverse and remand on summary judgment, could there be a viable trespass judgment as a result of the trial? Is the trespass trial or the trespass cause of action dependent upon who owns the property, which was determined via summary judgment?
So sure, the trespass claim, a part of that claim, as you know, is who owns the property. And so we have argued that ownership issue was actually tried, and that would be that could be reversed and rendered, we believe, because the issue of ownership was tried and LaTour put on evidence of ownership, argued that it had to prove ownership. Its corporate representative testified that.
So it was tried even though it was also addressed in summary judgment?
We argue that the ownership issue was tried, and LaTour's admitted that it was trying ownership, that it had to prove ownership as a part of the trial. Now, granted, there was a summary judgment out there, but LaTour asked for a jury question on trespass, an element of which necessarily was who owned the property. The jury question that defines trespass as entry on the property of another without consent of the owner. And so ownership definitely was an element of that.
In instructing the jury on trespass, did the court inform them about its finding with regard to ownership made in the summary judgment?
Right. And so LaTour did not request an instruction that ownership had already been established. I think if they had done that, we might be in a different position, but they didn't. Instead, they posed that issue to the jury. Much like in the Bennett case that we cited, it's out of the Houston Court of Appeals. In that case, there had been a partial summary judgment on the rate of attorney's fees, an hourly rate of attorney's fees, and the court had determined at the summary judgment phase, the rate was, say, $250. And yet when they went to trial on the attorney's fees issue, a question was asked to the jury how much attorney's fees, if any, should be awarded. Now, a subset of that question, an element of that would necessarily be the hourly rate of the attorney's fees. And yet the court said, well, by submitting the question that had that subset element to it, it impliedly overturned the summary judgment. And so we would say the same thing happened here by submitting the question and posing it to the jury. The court and LaTour were impliedly overruling that summary judgment, ruling as to who owned the property and asking the jury who owned the property. And
counsel, did you ask for that as part of your rendition point in your appellant's brief?
Yes, Your Honor. That is in our. We asked for a render on that claim.
But did you ask for a rendition on the argument that that LaTour waived the summary judgment or somehow lost the summary judgment by submitting that issue in the trespass case?
Yes, Your Honor. That's in our. I can't tell you exactly what page number, but that is in our brief. And the evidence at the trial, much like at the summary judgment, was LaTour's corporate representative saying that LaTour was not claiming ownership, that it wasn't even seeking ownership of the property north of the wedge as part of this lawsuit. They just wanted to use it. They continuously said that they weren't seeking ownership of that property, that 2027 owned the property, that 2027 owned the property where the poles were. And so the judgment that says, oh, the pole, that entirety of tract 2, including the property north of the wedge, is just contrary to both the deposition testimony and the testimony at trial by the corporate representative that admitted the property was 2027's.
Let me ask you this: with regard to the trespass issue, was there an adverse possession issue submitted in the trial?
The adverse possession question, like as far as laying out the elements, no. But the issue of ownership was inherent within the question of trespass, and that there was evidence in front of the jury as to who owned the property. I mean, the corporate representative, like I said, kept saying over and over that he did not seek ownership, that LaTour is not seeking ownership, that it didn't own that property where the poles were. So it's, not surprising that the jury agreed with him on that. But going back to the summary judgment, really, the evidence conclusively negated adverse possession and the prescriptive easement, not the other way around. And as the court knows, the elements are the same for both and require that there's adversity. which courts have interpreted as exclusive use. I would encourage the court to read the Tran versus Macha case out of the Texas Supreme Court from 2006, which I think is highly analogous to this one. I'll just read the first sentence from that case. Neighboring relatives shared the use of a driveway for many years, thinking it belonged to one of them when in fact it belonged to the other. The Court of Appeals held that had transferred title by adverse possession, but the Texas Supreme Court disagreed, reversing and rendering a jury verdict that had been in favor of the adverse possessor, saying joint use is not enough. Similarly here, and in the summary judgment evidence, multiple witnesses say that the use of the parking lot on both sides, the entirety of the parking lot, was not exclusive to LaTour, that, quote, anyone could park there, regardless of what the signs on LaTour's wall said. Other witnesses said they had no clue who had parked there, and that's certainly not conclusive evidence that the parking lot had been, or I guess the tract 2 had been exclusively used by LaTour. Similarly, adverse possession and the prescriptive easement both require a claim of right, which means an intent to own the property. And the Texas Supreme Court, again, in that Tran case, has explained that occupancy without an intent to appropriate does not support an adverse possession claim. And again, people from LaTour say it was convenient to use these parking places, but no one says they were parking there intending to stake a claim over them. Even if they had believed they had owned the property, but they actually didn't, that still wouldn't be enough, as the Tran case describes. So yet
Are
again,
those facts in the summary judgment evidence, or was that the trial testimony?
so the trial that is in the summary judgment record for sure. And now I'm trying to think back on the trial.
The summary judgment record.
That is in the summary judgment record. Yeah. It is in the trial record too, because the LaTour corporate representative said that they did not have an intent to claim that the property north of that diagonal line. So I think it's both. And we've highlighted this next point in our brief, but I think it's just telling that there is not one contiguous decade that you can look at and say all the elements of adverse possession are met for this decade. LaTour has 4 or 5 witnesses and tries to patchwork together a case of adverse possession from these 4 or 5 people, but they all talk about different decades, different things happening at different times, and there's not a period of time where you meet all of the elements. Really, the older testimony goes back to the 80s and 90s. The witnesses from that time had, quote, no clue what was going on with that parking lot and didn't really pay attention to it. Their testimony really is not conclusive proof of anything. They didn't know. When you get into kind of more recent memories in the 2000s, people know more, but what they know actually helps the defendant side of the case, because they know that the parking lot was used mutually, the entire parking lot, by both sides. Both entrances were used mutually by both sides, as long as anyone could testify. And so there's just not a period of time that meets the 10-year statute. I do want to address the signs, because I suspect that Mr. Lovell will want to talk about those.
Let me ask, before you do that, let me ask you with regard to prescriptive easement. You're attacking that as well?
Yes.
Does mutual use affect the validity of a prescriptive easement? A mutual use over the last 20 years?
So exclusivity is an element of a prescriptive easement as well. And that's in the Brooks versus Jones case, which is a Texas Supreme Court case. And it says it is an easement case. And it says if both the record title holder and the one trying to claim the prescriptive easement have both mutually been using that right of way over the period of time, then adversity is not established as a matter of law. And so the fact that both sides were using the parking lot during this entire time conclusively negates both the adverse possession and the prescriptive easement. I think in this case, we're remanded back down. A summary judgment ought to be granted in the defendant's favor because there's just conclusive proof that the elements are not met.
Was there any claim or request with regard to an easement by necessity, or was?
No, it's been a prescriptive easement.
Okay.
So I just turn back to the signs because it also ties into the issue we highlighted in our brief about the meets and bounds. The signs are posted on the wall of the LaTour parking garage that borders this parking lot, and they don't say a thing about ownership. They don't say it's LaTour's property. They don't say they're claiming the property for LaTour. And even LaTour, its witnesses make this clear, even LaTour didn't take those signs seriously because they never enforced them. They never towed any car. As far as the summary judgment record goes, they never towed anyone. And they legally couldn't have because the signs didn't follow the tow statute. But also, there were only 4 signs along this stretch of wall with 10 or more parking spots. It's not clear how putting a sign on your own property could claim land that's far away from those signs that's not on your property. It's not clear what land these signs would allegedly be claiming, where that boundary line is. And again, this ties into the issue of the meets and bounds set out in the judgment are not supported by any testimony. There's a survey that's filed in the record that the judgment, I guess, apparently follows that. But that survey itself is not tied to, we don't know where the lines are on that survey. Are they edge of the parking spot, or are they enough to accommodate a F-350? Are they 15 feet from the wall just because that's how much a typical car length is? We have no idea where that line is drawn, and there's just not any evidence to support the actual boundary line. And the witnesses talk about, the boundary in terms of roughly half or kind of there, and that's just not enough to conclusively prove adverse possession over a set piece of land.
One of the exhibits that got included in the motion for summary judgment was, it looks like it's page 87 of the record, is a photograph of a parking lot that's got a blue stripe and the sign's already up. Now, I know that question of whether the signs can be put up is one of the issues before the court, but doesn't that provide some evidence of where the boundary line was so that we could determine if the signs had any application or not?
So the blue,
I'll show you the photograph I'm talking about. I don't know if you can see that or not. Maybe not.
it's cutting out on your
Sorry.
background.
Yeah. The wonders of the internet.
That's right. I think I do think I know what picture you're talking about though.
It's deposition exhibit 1 for Del Pozo.
Okay. So that blue line was painted on the ground to follow the deeded titled boundary line. And so we say that is where the line is and should be. The judgment draws the line as a rectangle and not a triangle, to put it just in terms of geometry. And so
Yes, you had two triangles, one triangle that covers LaTour's original title to the property, or the part that's deeded to the LaTour. And then the other part that the district court granted was the other half of the triangle that forms a rectangle when you put those two together, right?
Correct. And my point is that I don't think there is summary judgment evidence to support where the northern side of that second triangle would be.
Okay.
And so It's just another fault with the summary judgment and the judgment as well. And so I will just briefly discuss the cross appeal point on LaTour's attorney's fees. The jury found 0 on the reasonable and necessary question as to LaTour's fees, and the trial court declined to award its fees on a declaratory judgment. As the court knows, you can't overturn the trial court's decision absent a clear showing of an abuse of discretion, because that was within the trial court's discretion to award fees or not. And there's not a showing in the record. There were no findings of fact requested on the attorney's fees issue. And therefore, there's no showing of the trial court's reasoning. We've cited a number of cases in our briefing, but even awarding fees to a losing party on a deck action is okay. Certainly awarding no fees to anybody was also within the trial court's discretion, and I don't think there's any cause to reverse that portion of the trial court's decision.
Procedurally, on the attorney's fees issue, that was not included in plaintiff's motion for judgment on the jury's verdict. Is that a waiver of that issue?
I do think, Your Honor, that they raised it in their motion for new trial.
Okay. Yes. Okay.
And so I think I don't want to say they preserved it, but I think they did in the motion
Yeah.
for trial. But I don't think that's, I still think they ought to lose that point, because it's well within the trial court's discretion to award a 0. And so.
Did you have a motion for attorney fees, or did you seek that relief as part of your petition, part of your client's petition?
We acknowledge that the trial court was within, and I'm answering your question. I see I'm out of time.
Please do.
The trial court was within its discretion to not award our attorney's fees on the deck action, but since we've asked for a reversal on that point, we'd also ask that you would reverse and remand that, as well as is the custom for courts when they're looking at the merits of an issue, to remand the attorney's fees with it, since that certainly should be part of the equity and justice analysis that the trial court would perform.
I was just trying to be clear on which one you were asking for, because you'd also asked for a rendition earlier, and so I was trying to figure out if you wanted a rendition on half, rendition apart, remand the whole thing.
Yes, and the trial, I think that does overly complicate the trial, I think, but the prescriptive easement portion was the deck action. And that's the only part related to the attorney's fees. I don't know that there's a vehicle for the court to render on the prescriptive easement part. And so I think that would be kicked down with it. Does that answer the question?
It does. Thank you.
Any other questions? Thank you, counsel. Mr. Lowe.
May it please the court and counsel. What we have here is a case where there are no witnesses to contradict 50 years of adverse use of this parking lot. There's no witnesses to say that there was any permissive use. And indeed, 2027 has admitted they have no evidence and they have no witnesses to contradict anything that was testified to.
But if everybody, can actions contradict oral testimony, or can actions fill the void? And those actions being that over that period of time you just mentioned, people from both residential facilities were using the area or the real estate in question?
There may be witnesses out there who could testify that once upon a time they saw somebody from 2027 parked there, but we hadn't found them. And really, Judge, under the Scott versus Cannon case, that wouldn't be determinative anyway. The Scott versus Cannon case defined what exclusivity actually is. And that case found that even with mutual use, it doesn't have to be exclusive use that as long as the adverse claiming or prescriptive easement claiming party makes clear to the fee title holder or the record title holder that the use is adverse, that takes the place of a exclusivity element. And that's what we have here. And really the Scott case is the most applicable case to this circumstance.
Is exclusivity element related to, is it a fact question, or is that something that the trial court decides as a matter of law? Would that be an element that'd be submitted to a jury as opposed to a judge making that decision?
If there was contested evidence, it might be, but really that fact wasn't a contested fact. The fact that
wasn't counsel saying it is contested by the evidence that everybody was using it, not just your client's people?
No, and this is explained pretty well in the Scott case at pages 721 through 723, that where you have a mutual use situation, whether it's a parking lot or whether it's the road easement discussed in Scott versus Cannon, that there doesn't have to be exclusive use or exclusive possession. There only has to be an adverse use or adverse possession, and that adversity has to be made known to the deeded title holder through some action other than use, whether it's a sign in our case, whether it's repairing parking lot or repairing the road, which occurred both in the Scott versus Cannon, also occurred in this case. So it's slightly different elements of proof actually required. And one of the things I think is important when you take an overview of adverse possession cases or prescriptive easement cases, in order to determine what the appropriate inferences are from the evidence, one has to look at what the property is and what the property is used for. What is the property suitably used for? Well, a parking lot is suitably used for people to park on. And you don't have guards, you don't have fences, you don't have locks to lock people out. Okay, so it's used as a parking lot, and it needs to be viewed from that point of view. Same as the road in Scott versus Cannon. And what we have here, actually, Judge, is only semantics debates among lawyers versus laymen about what does fee simple mean and what's deeded title and what does own mean. Does own mean limitation title? Does own mean deeded title?
Now, Mr. Lowell, can I ask you a question?
Sure.
I can't show you the exhibit, obviously, but the exhibit I was referring to a while ago, the Del Pozo exhibit.
Yes.
And what I was talking about with Ms. Knapp was, we've got the blue line. We understand where LaTour's property is. We understand that part of the triangle.
That's the northern deeded property line.
We're trying to figure out where the other part, the part that was awarded to your client, we're trying to figure out where that is. And
Where the parking stripe. I'm sorry, I spoke over you.
No, it's okay. My question, I guess, is this: is it your argument that the signs that were placed on LaTour's property, on LaTour's building, put the appellant on notice that you were making a claim to the property interests north of the blue line?
Yes. Title where the parking stripes are.
In other words, I understand it. I understand in a lot of the cases that are cited by both parties, when people are adversely possessing land by grazing or whatever, the evidence there on the sign is that the sign is put on the adversely possessed property, not on the possessor's property. And so that's what I'm trying to understand, is what significance, if any, does the sign have if the sign was placed on your property?
It's placed in front of the parking spaces. And when you look at that exhibit, you will see the painted parking stripes to show what slots to park cars in. Every car that parked there in those slots was looking at that sign, or one of those signs. So what was adversely possessed to own was that portion of the parking lot covered between the parking stripes on the south side, and then a prescriptive easement over the middle to allow cars to get in and out to those south side parking slots.
But there's some area that is within your property line where cars are able to park. In fact, the exhibit itself has what looks like a Cadillac or something that's parked into one of the spots that's clearly on LaTour's property. And I obviously don't know where the signs are along that wall, but given that we're dealing with this at the summary judgment stage instead of at a trial stage, does it at least raise a fact question about whether the signs are putting people on notice about where the other part of the line is that you're claiming?
Well, first, the part of the parking lot where a car is capable of being completely parked on the deeded property is 1 or 2 spaces on the far east end. But when you get beyond that, those 1 or 2 spaces on the far east end, every other parking slot would have the back part of the car north of the blue line. And when you think about it, Judge, you go into a parking space and you see the stripes on the left and the right of the car and the signs in front. It's pretty obvious, I think, that when a sign is in front of a car that's parked, it's making the sign applicable to the parking space where the car is. Now, the blue line was only placed there really once the dispute arose, and I'm trying to remember whether it was immediately before or immediately after the lawsuit was filed.
Yeah, I know. I understand that part. I'm only using the blue line as an illustration of, for purposes of using this as an example, we know where the line is established, at least according to the blue line. So I understand that part of your argument.
Yeah. There's an important presumption that needs to be considered by the court, and none of the parties cited this case. And the case is Pete versus Stevens, 582 Southwest 2nd, 892. It's a 1979 NRE case from San Antonio that once a state of things or a status is shown, it's presumed that that status continues. Obviously, that's a rebuttable presumption, but in this case, it never was rebutted. And so on the point that there has to be direct evidence of every element of proof within the same 10-year period, that's not true, because the law recognizes that once a state of things is shown, it's presumed to continue. Well,
was that
that's what happened.
Was that case a summary judgment case?
No, I don't believe that case was. Pete versus Stevens arose in a summary judgment context. But as a rule of evidence or case law defining a rule of evidence, that's what happened here. And when you look at the evidence, all the witnesses, that's what they're saying, is that it's been the same for 50 years. The parking lot's been used and people have presumed that it belonged to LaTour. They intended to own it. They fixed it. They painted it. They told their employees on it. They put signs on it. That was continuous.
Did they presume that LaTour owned it, or did they presume that we can just park there, which are not two different things?
So, possibly, but some of the witnesses what they testified is, we hadn't really contemplated title ownership. They hadn't really contemplated the fact, most of them don't know, that once a 10-year period of adverse possession has passed, title vests, even if you don't know it. Title vest, even though there's no determination, there's no adjudication. Laymen don't know that. Some of the witnesses just hadn't
When was the first manifestation by LaTour of ownership, of exclusive ownership? When did they first say, hey, this is our property?
From the evidence available and from the witnesses that are still alive, which is another issue, it's been this way so long that the witnesses in the early 60s aren't around anymore. But the evidence clearly goes back to the early 80s that LaTour always considered it theirs, and They used it.
Well, they used it, or did they say, yes, it's ours?
I'm sorry.
Did they just use it, or did they say this was ours and then told the neighbors, yes, this is ours?
Well, they told the world it was ours when they posted the signs there, and the
When
signs
was
have
the
been there
sign
so
post- When was the sign posted?
longer than anybody could remember, at least 18 years. One witness was able to say they were up when I first moved in, and that was 18 years ago. But, well, just that. They've been there so long, nobody can remember how long they've been there.
Mr. Lovell, I've got one more question for you, or a couple of questions about the actual act of the cars parking in the spot, because I think you argued that there's summary judgment evidence that the fact that folks have parked there who were LaTour tenants for that long is evidence of adverse possession. Both sides cite this Anzaluda case out of the San Antonio court from 1956. And what it looks like there is you've got people who are joint tenants but they have to act in concert with one another. And you didn't address the joint concert part as a portion of your brief, and I was going to give you an opportunity here. Is there any evidence that when somebody parked there in 1982, that they knew that there was another joint tenant who was also parking in the lot, and that the intent of people parking in the lot on this property line was intended to claim the property for adverse possession, or what does the law require on that?
Well, the law just requires that they be acting in concert to some degree. It doesn't define what that necessarily means, because it would depend on the circumstances. Here,
what evidence was there that they were acting in concert here?
Testimony by the managers that they were told when they first came in and became managers, they were told, tell contractors to park over here, tell guests to park over here. This is where you tell people to go to park when they come up to visit somebody at LaTour or to do work in one of the apartments. And then, you know, all the witnesses, all the tenants testified to the same. Oh yeah, that's where I told my children to park when they came up and see me. I saw contractors park there when they came to work here. So they were in concert, and there was testimony that that was actually directed by LaTour management to use that.
Different, this was ownership tried in the
No.
trespass issue?
No, it wasn't tried.
Why not?
Well, it had already been determined by summary judgment.
But then the issue was submitted to the jury though, wasn't it?
I didn't hear the question.
The issue was submitted to the jury implicitly, wasn't it, when in
No.
the elements of trespass?
No. Elements of trespass and adverse possession are different. The jury was not instructed on any adverse possession elements nor any prescriptive easement.
Well, adverse possession addresses ownership, correct? To a certain extent.
There is some ownership involved in adverse possession cases, but the elements are different.
In trespass, is there an ownership element?
It's implicit that property is owned. It's important to point out, though, that that jury question, number one, didn't ask ownership. Number two, it failed to find trespass. That's not the same thing as saying it found there was no trespass. Those are different elements. It was a failure to find a trespass. That doesn't implicitly find that there was not a trespass. It was just a failure to prove trespass.
It doesn't look to me like there was an instruction by the court to the jury that your client owned the property. Was there a request made for that instruction?
No, but the deed was put in, or not the deed, the summary judgment order was put into evidence. and so the jury was aware of that. What I believe happened with the jury is that what the evidence showed was that at the time the spike poles were placed, there had been no determination on whether or not an adverse possession title had vested in LaTour. It was still a disputed issue. so that at the moment the spike poles were put in, that particular spot where the spike poles went was shown under a deed to 2027. After the poles were placed, that's when Judge Woodburn determined that it was owned by adverse possession. And of course, we don't know exactly, but it would make sense that the jury would say, well, when he put the poles in there, he thought he owned it. We shouldn't hold him liable for putting poles in there when the judge hadn't determined it yet.
To what extent can evidence at a trial contradict the basis for a prior summary judgment?
I'm sorry, Judge, I didn't hear the
To what
question.
extent can evidence at a subsequent trial contradict a previous summary judgment? Ms. Knapp indicated that at trial, LaTour's representative said, no, we're not claiming ownership.
That's
Never
part of
claimed
the
ownership.
semantics debate.
Well, no. Well, you didn't argue to the jury, oh, that's just semantics, did you? And you got to ignore semantics? Or was the jury entitled to rely on your client's representative saying we're not claiming ownership?
What they were entitled to rely on was a complete statement in the testimony. And when you look at the testimony on those topics, the definitions of what the question was about vary, the terminology varies, and one really needs to read the entire dialogue to get past the semantics games being played by the attorney.
Aside from saying there's semantics, if the summary judgment, the trial court said X owns the property, but at the trial, X gets on the stand and says, no, we're not claiming ownership. Can the subsequent evidence at a trial negate the previously issued interlocutory summary judgment?
If an interlocutory order can always be changed, and it could if the judge or the trial judge would have the ability to do that. He didn't in this case.
Let me ask you this. Did anybody ask the trial judge to, in motion for new trial or anything along that line, say, Judge, given what the jury decided with regard to trespass, you got to redact your summary judgment adverse possession order?
Yes.
You got to vacate it?
Yeah, that was moved. We actually had 2 hearings on that after the trial.
So that was raised. Okay.
Yes.
Okay.
Yeah, it was raised.
I know you've only got a minute or so. I wanted to ask you about an issue involving your cross issue. You asked for rendition of a judgment. You filed that in the court, and as a part of your motion, you said plaintiff seeks to have the court enter judgment based upon the jury's verdict, this court's December 6th summary judgment order, the live pleadings of the party, the evidence, admissions, etc. By asking for the court to render a judgment based upon the jury's verdict, did you waive the issues involved in your cross appeal? Can you ask the court to render judgment and then complain about the court's judgment later on without reserving anything there?
Well, we reserved that through our motions for new trial. We pointed out those errors, and we believe that in fact the finding of no trespass should be, or the failure to find a trespass should be reversed under the evidence anyway and rendered. And this court has the ability when a case is fully developed, and when the evidence on a point is fully developed, as the case is here, where you can render.
I'm assuming though the motion for new trial was filed after the judgment was signed, right?
Frankly, I don't recall.
Okay.
I don't recall the sequence.
Any other questions?
I don't have any further.
Thank you, counsel. Rebuttal, Ms. Knapp?
Your Honor, first to address the adverse possession prescriptive easement issue, I think Justice Quinn asked when was the first time LaTour claimed the property. I would say never. There's not one witness that says they were intending to claim the property. And the law is clear that for an adverse possession claimant to succeed on their case, they have to occupy with the intent to appropriate, and the possession has to be of such character that it indicates a, quote, unmistakable claim of exclusive ownership.
But do you need a live witness to say they claim that property, or can actions be enough, such as putting up a sign saying, this is our property,
I don't think there is.
or just park here?
Certainly in this case where there's not even a sign that says this is our property, here's the boundary line, that's certainly not enough. And especially at the summary judgment phase where they needed conclusive evidence to prove their claim. There's not.
Refresh my memory as to what the sign actually said.
Your Honor, it said, and I'm going off memory, LaTour condominium.
Your memory is better than mine for sure. So
I think it said something to the effect of LaTour condominium, guests and tenants parking only, others may be towed.
okay.
Something to that extent. It did not stake an ownership claim. It wasn't legal under the tow statute. They couldn't have enforced it. They didn't enforce it. They said anyone could park here. To go to Mr. Lovell's point as to what managers said, there were 2 managers deposed going back to only 2007. And they said, oh, anyone could park there. The manager that was from 2007 to, right before the depositions were taken, she said everybody always parked on both sides. Anyone could park there, never enforced it. And I knew that the diagonal boundary line was the correct boundary line, and everything north of that line was 2027's property. And
Did you cite to a case in your brief, I can't recall, that said there was a no trespass sign, but everybody ignored it, so that doesn't constitute evidence of being ousted from the property? Or
right. So there are very few cases that we found talking about trespass signs. One was the Vaughn case where a guy posted no trespassing signs around, kind of described it like a cabin in the woods. And he went there, he improved the cabin, he did all kinds of things, took his kids there, hiked in the woods, all of this. And they said and paid taxes on the land, which LaTour never did here. The court just said, yeah, even though you have all of that, even though you put up no trespassing signs, that's not enough. And we also cited, I think it's the Kings River Association case where you had some hiking trails that were maintained really by 2 different groups. Neither one of them excluded the other, and that also was not sufficient. And I would just say on the exclusivity point that Mr. Lovell brought up, I'd refer the court back to the Tran case, which is 2006 and more recent than the ones that he's talking about, that are very clear that say joint use is simply not enough. And as far as the effect of the jury verdict, I think the fact that LaTour stated to the
is joint use not enough as a matter of law, or does it raise a fact question as to exclusivity and intent?
The Tran case was a reverse and render of a jury verdict, so that was as a matter of law. It was not enough. But at trial, LaTour stated to the trial court it had to, quote, prove ownership in order to establish the trespass claim. It put in evidence of ownership. On cross-examination, the LaTour corporate representative testified without objection by LaTour as to issues of ownership, who owned the land, where the poles were, north of that blue line that Justice Doss pointed out. All of that came in without objection of LaTour. LaTour put in evidence of its chain of title, all kinds of stuff that did not go to anything else other than the ownership issue. LaTour asked for the question on trespass that was submitted that contained the ownership element, and did not ask for an instruction from the trial court that the ownership issue had already been determined, and then asked for judgment on that verdict. And I do believe that that was before the judgment was rendered, and the motion for new trial was filed after the judgment. So we'd ask for the reverse and render / reverse and remand that we've described in the brief. And unless the court has other questions.
Any questions? You have given us some great issues to ponder at the beginning of this new year, and we will most definitely ponder them. We want to thank the council for appearing via Zoom. Someday, hopefully in the near future, we will be able to see you personally in the courtroom. we missed the opportunity to do that. But with that said, the case is submitted and we will be in recess.